Good morning, everyone. Welcome to today's webinar brought to you by LegalVision. We are going to be discussing the aged care labour agreement and how businesses can utilise that to bring overseas talent to their aged care or healthcare business. Now, there is a fact sheet on the aged care labour agreement that you can download. That was on the first slide. So when you receive a copy of these slides, you'll be able to access that. I just want to introduce myself. My name is Yin Chiew. I'm the practice leader of the corporate immigration team at LegalVision, and my colleague Kaku Caro, who's a lawyer in the team as well. Thank you for joining us today. So before we begin, you will receive a recording of this webinar and a copy of these slides to your email that you've registered with. If you have any questions throughout this webinar, feel free to submit your questions in the chat box and we'll have time to answer them towards the end of the webinar. And we would really appreciate it if you could complete the feedback survey after the webinar. So as part of attending this webinar, you can claim a complimentary legal consultation with our corporate immigration team, and it can be in relation to the aged care labour agreement or any other labour agreements that you might be interested in as well. So if you are interested in that, don't forget to leave your contact details, provide a brief explanation of what kind of assistance you need, and we'll get back to you and organise that complimentary consultation with you as well. So today we're going to talk about the aged care labour agreement, but first we're going to talk briefly about, well, what are labour agreements, because that's quite important to understand. We'll talk about generally the aged care labour agreement, an overview of it, and then we'll discuss specifically the terms and conditions of the aged care labour agreement. We'll also talk about what are the best practice for negotiating the Memorandum of Understanding, the MOU, and what is the process for requesting an aged care labour agreement. And there'll be time for some questions and answers as well. So the first category is, well, what are labour agreements? If you're not familiar with that process, it can be quite a confusing and onerous step. A labour agreement is essentially a contractual agreement between the Australian business and the Australian government, namely the Department of Home Affairs. And there are many types of labour agreements. We're really talking about one in particular today, which is the aged care labour agreement, but there is the company-specific labour agreement that is tailored to the specific needs of the business, and that really is for those clients that can't access another labour agreement. Now, there are industry labour agreements, which is where the aged care labour agreement falls under. There's about 8 or 9 industry labour agreements all across different industries and sectors. Now, not all industries and sectors are covered, unfortunately, but some key industries and sectors are. There are also designated area migration agreements, otherwise known as DAMAs, and they typically cater to businesses and positions that are in designated regional areas. They have been already pre-negotiated by the Department of Home Affairs, so there is a head DAMA usually in place for that specific region. And then there is also the less common project deed of agreement labour agreement. So we'll just move on to the next slide now. So when you're considering a labour agreement, such as the aged care labour agreement, it is important to understand what are the requirements of the labour agreement, what are the considerations, in requesting that labour agreement. The key factor here is understanding that a labour agreement is not an application. So if you're familiar with the employer-sponsored visa process, you would understand that you submit an application. If you meet certain criteria, then it gets approved. That is not the case with the labour agreement. You are submitting a request to the Department of Home Affairs, particularly the labour agreement team, to enter into a contractual agreement with the Department of Home Affairs. So before the Department of Home Affairs will agree to enter into that agreement with you, they need to be extremely satisfied of your business case positioning and why you want that labour agreement. So if you are successful in requesting that labour agreement, it's important to note that it is approved for a period of 5 years, starting from the date that it is formally executed, and that it is typically targeted towards businesses that have been in operation for at least 12 months. So it really isn't suitable under all the labour agreements that we discussed for businesses that have been in operation for less than 12 months. You do have to provide a strong business case with any labour agreement that you request, and we'll talk about that momentarily under the aged care labour agreement. Once approved, there are sponsorship obligations that the business must satisfy, and then usually afterwards you can submit the associated nomination and visa application for that particular visa program that you've been approved for under that labour agreement as well. Another important factor to note is because this is not an application, that there are no indicative processing times. It can actually take many, many months, maybe longer, for a labour agreement to be processed. That's certainly the case with company-specific labour agreements, though we do find that with industry-specific labour agreements, there is a bit more of a prioritisation involved in that. But it's important to consider this in your planning, because if you're considering sponsoring certain workers and you need them in the country by a specific time, the first step of requesting the labour agreement doesn't provide any indicative timeframes, and it's really up to the actual labour agreement team on behalf of the minister to decide or process it in accordance with their own timeframe. So it's important to plan accordingly as well. So we'll just move on to the next slide there. So what is the aged care labour agreement? Well, it was introduced in May of this year, so it's relatively new, and it is an industry labour agreement. It does specifically cater to the aged care sector. What's important to consider here is that only aged care providers, so businesses that operate residential nursing homes or aged care facilities, are eligible or would be the target business that can request an aged care labour agreement. For other businesses that may operate in the healthcare, such as NDIS providers that offer in-home age or disability support care to your clients and patients, this is not suitable for you. You're probably looking at a company-specific labour agreement. And we can certainly, if there are attendees here that do own their own NDIS business or are NDIS provider and don't fall under the aged care labour agreement, we can certainly discuss with you what the requirements are of a company-specific labour agreement on a complementary basis as well. So don't forget to leave your details towards the end of this webinar. We can certainly explain that to you so you're fully informed of the process before you make a decision to proceed or not. But going back to the aged care labour agreement, so having identified that the appropriate type of business is an aged care provider that operates nursing or aged care residential facilities, those businesses can request an aged care labour agreement. You can nominate one of 3 occupations or all of the occupations, which is nursing support worker, personal care assistant, and age or disabled carer. And we'll talk specifically in the next couple of slides about what are the skills requirements involved, but I just wanted to give you a bit of a summary historical background. Before the aged care labour agreement was introduced, there was very limited options for aged care providers to access these skills to nominate these occupations. Typically, they would have to request a company-specific labour agreement, and there were certain terms and conditions of that labour agreement that were already set, and specifically around the skills requirement, which meant that the foreign worker that they wanted to sponsor, the skills that they needed, needed to demonstrate that they had at least 2 years of post-qualification work experience. You will see with the aged care labour agreement that has fundamentally changed, and that can be considered beneficial to an aged care provider as well. So there were limited options, the company-specific labour agreement, and then only businesses that operated in designated regional areas could access a DAMA if that particular DAMA had one or all of these occupations available. Obviously, many aged care providers don't operate in designated regional areas, so that limited the options greatly prior to the introduction of the aged care labour agreement. But the key advantages of the aged care labour agreement is that there are these 3 occupations that are obviously part of the skills shortage and are in demand. There is a streamlined pathway to permanent residence, typically after 2 years. There is a more simplified priority processing of nomination and visa application, and there is no need to demonstrate a certain amount of post-qualification work experience for the 482 visa. It's quite interesting to note as well that the Minister for Home Affairs actually conducted an interview on the 11th of September, and he did confirm that there's only been 8 aged care labour agreements approved so far. And when we're talking about an industry of over 800 aged care providers across Australia, that's obviously a very small amount. But given that this aged care labour agreement was only introduced in May, it's still very much in its infancy as well. So we'll just move on to the next slide. So what are the terms and concessions of the aged care labour agreement? A mandatory step, and we will explain this in more detail. My colleague Kaku Caro will go through in a lot more detail around the process of entering into a memorandum of understanding. But the first key consideration and a mandatory step is for the aged care provider to negotiate and enter into a memorandum of understanding with the relevant union. Excuse me, sorry about that. There are 3 relevant unions that the aged care provider may be in discussions with, and that will be dependent on the occupation that they want to nominate under the aged care labour agreement. But as I explained, my colleague Kaku will explain more about this process later on in this webinar. Obviously, the occupations do not fall under your standard occupation list. They are specific to the aged care labour agreement, and they were outlined in the previous slide. So they are personal care assistant, aged and disabled carer, and nursing support worker. The aged care labour agreement allows aged care providers to utilise the 482 visa program and the 186 permanent residence program as well. So with them meeting certain skills and requirements, you can sponsor a 482 visa holder in one of the 3 occupations or all of them, depending on what you need, for up to 4 years. And then typically after a transition period, or maybe it's a direct nomination, you can nominate them for permanent residency on the subclass 186 as well. So this is a fantastic option for aged care providers that need to retain this skill and be able to give those workers some level of certainty that there will be permanent residency pathways available after a period of working with the aged care provider. There are also concessions to salary as well. So as you know, from 1 July 2023, the TISMET, or the minimum salary component, increased from 53,900, I believe, to 70,000. Under the aged care labour agreement, the actual minimum salary is 51,222. So there are salary concessions available as well. So moving on to the next slide. So in general, really understanding what the skills requirements are for those workers that you want to sponsor. The great news with the 482 visa under the labour agreement, under this aged care labour agreement, is that they don't need to demonstrate a minimum post-qualification work experience. So in the first box, they can basically meet one of those criteria. They can have the relevant educational qualification. If they don't, they may obtain a positive skills assessment. If they don't, then a certain amount of work experience could substitute for the formal qualification as well. So those are the minimum skills and qualification requirements. And this is, as I explained, quite different to the previous avenues available for aged care providers, where they needed to demonstrate at least an educational qualification plus 2 years of post-qualification work experience. So there is no such thing for the 482 visa under the aged care labour agreement. English is also slightly a little bit lower as well, and there's no age limit for the 482 visa. However, when moving on to the permanent residency pathway, there does need to be minimum work experience or skills. So an educational qualification and at least 2 years of work experience in one of the direct care occupations. Now, the great thing about the aged care labour agreement too is that there are two options or two pathways to permanent residency. One is after an applicant has been sponsored on a 482 visa under the aged care labour agreement for 2 years, then they can transition to permanent residency under the 186 under the aged care labour agreement. Or if they have 2 years of full-time work experience in a direct care occupation, and that was work experience in Australia, the aged care provider can nominate them for permanent residence directly under the aged care labour agreement. Obviously, they still need to meet English competency standards. They still need to be under the age of 45. Unfortunately, at this stage, there's no age concessions, and usually these terms and conditions for the aged care labour agreement are set. There may be a way to vary the terms of the agreement after the agreement has been executed and approved, usually maybe in the 3rd or 4th year. But at this stage, when you're requesting the initial aged care labour agreement, the terms and conditions will be set as well. As part of the aged care labour agreement too, because it's in operation for 5 years, you will be able to nominate a certain amount of places based on the occupation that you want to sponsor per year under each visa subclass. Now, usually you would negotiate that for the first 1 or 2 years and then come back and request a deed of variation for amended nomination ceilings in the 3rd, 4th year as well. And you would likely have to request the permanent residency pathway through a deed of variation as well. Again, if this is something that you're very interested in knowing more about, we offer the complimentary consultation where we will explain this to you in a lot more depth and tailor it specifically to the needs of your business as well. So we'll just move on to the next slide. So what is the process for requesting an aged care labour agreement? As explained, there is no specific time frame. It takes for the Department of Home Affairs to process a request for a labour agreement. So you need to plan appropriately. This could take several months, and certainly the preparation of the business case for the request for the aged care labour agreement is quite an extensive process too. But the first step is reaching out to the relevant union to discuss and negotiate the memorandum of understanding. And as I said, I'll leave that to Kaku to explain in a bit more detail what that process is, what is the purpose of the memorandum, and some of the benefits that it provides an aged care provider in this process of requesting an aged care labour agreement. Now, if that all goes well, and you're able to enter into the MOU with the union, and you're able to supply an executed MOU, then you can start the process of preparing all your documentation, your business case to request the labour agreement. So as explained, the Department of Home Affairs, because they're entering into a contract with you, they need to know a substantial amount about your business, how long it's been operating, what type of business is it, what kind of aged care facilities does it offer, is it compliant with any regulatory framework that oversees the provision of services in a residential aged care facility. Have you conducted labour market testing? Have you tested the market? How will this aged care labour agreement benefit the business? How you will try not to overuse the aged care labour agreement to fill your skills shortages? How that aged care labour agreement will help in the training and facilitation of development of Australian workers within your business. So there is a lot to prepare here. There's a lot to submit here. And in our case, when we prepare business case submissions, they're usually in the vicinity of about 50 to 60 pages, plus supporting evidence and documentation as well. Now, because you've already consulted with a union, you wouldn't necessarily need to go through a stakeholder engagement process under the aged care labour agreement as you would with, say, a company-specific labour agreement. It doesn't mean you can't provide letters of support from organisations that know about your business, that understand, that appreciate the skills shortage that your business has experienced, and may want to offer a letter of support as well. So once that's all prepared and you submit that with your request for a labour agreement, then it can take several months to process, or at this stage, it could be shorter as well. We really don't have any indicative timeframes at this stage. And then once it is approved, you can submit the associated nomination and visa application for that specific visa subclass as well. So we'll just move on to the next slide. So I'll hand it over to my colleague now, Kaku, who will discuss with you what the best practice is for negotiating an MOU.
Fantastic. Thank you very much, Yin, for that introduction. So again, once the business is ready to actually proceed and actively consider this ACLA, the Aged Care Labour Agreement, this is a very, very first important step. It's a mandatory requirement before being able to actually submit a request for an ACLA with the Department of Home Affairs. So let's talk about what is actually a memorandum of understanding first. So it actually sits in between a written contract and sort of a handshake deal. It is a preliminary written agreement that it's outlining a framework of key terms between the business and the relevant union. And this is very useful because it basically ensures all the parties are on the same page. They understand what their obligations are under this memorandum of understanding. And generally speaking, a memorandum of understanding is not legally binding. However, upon executing this memorandum of understanding, submitting the request for an aged care labour agreement, and if all those steps are successful, the contract, the aged care labour agreement contract, will actually stipulate that if the union retracts from the Memorandum of Understanding, the aged care labor agreement contract can be rescinded. So it's important to know that even though this Memorandum of Understanding is not legally binding, it does have direct consequences to the, the aged care labor agreement. So that's really important to point out. Now, the Memorandum of Understanding actually serves as an alternative tradition to labor market testing, which is usually a mandatory requirement for other type of labor agreements, such as the company-specific labor agreement, which my colleague Yin has mentioned before, and also just standard 482 nomination applications to actually sponsor migrant workers. If we move on to the next slide, we're now going to talk about the process. We can divide this into 4 key steps. Obviously, the first step is getting started, taking action, and being proactive in your approach. So our recommendation is for the business to make first contact with a relevant specific union, which again, there are 3. It's the Australian Nursing and Midwifery Federation, the Health Services Union, and the United Workers Union. Now, which of these do you need to contact will depend on which ANZCO occupation you wish to rely on. You may need to contact 1, 2, or in some limited cases, all 3. And once you establish that first contact, we understand that these unions may take up to 10 business days to reply. And basically, who do you need to contact inside the union also needs to be taken into consideration, because unions have also federal offices and they have state and territory-wide headquarters, and depending on which particular state within the union you need to contact will also depend on where is the business located? Are you offering services all across Australia or in a specific region within a state or territory? And that's also useful information for establishing that first contact. Then obviously we move on to step 2, which is, once that initial contact has been set up, you will have to undergo some sort of union meeting in which basically the union wishes to confirm who is the organization, do you meet the eligibility criteria? They also want to understand the workforce, what sort of policies, what sort of rosters, hourly work, working conditions do you have for your staff in that specific occupation. Now, this meeting is very useful because it just ensures that both parties, have a shared understanding of the same terms of what you're actually going to establish in a memorandum of understanding. And there is a memorandum of understanding template should you wish to peruse it and just to understand what are generally the key terms that most of the unions will want to see. Obviously, step 3 is the union engaging with the current employees of your business. And again, this is important so that they can get a snapshot of what are the working conditions, the hours, policies, what's currently being offered to your Australian workforce, and also understand and have a look at what have been your recruitment practices in the past, and are you experiencing labor shortages, which it's quite common in this particular industry. Just to basically protect both Australian workers in Australia in these relevant industries, and also migrant workers either coming from overseas or being sponsored into your business, just to ensure that migrants' rights are also protected. Now, obviously, the last step is just the development and approval. This is one of the key, major, most important steps within this negotiation, because obviously, without proceeding with the execution of this memorandum of understanding, basically the business cannot continue proceeding with an ACLA because it is a key requirement for lodging this type of request. So that is the negotiation of a memorandum of understanding, just a general and high-level summary. And just to recap on the process that my colleague has mentioned before, step number 1, form a memorandum of understanding with a specific union in the specific region, which is, dependent on which occupations you would like to sponsor, submitting a request to the Department of Home Affairs once that memorandum of understanding has been obtained. And obviously, once the business, and if you, for example, need to engage us, once we have also established that we have, a strong preliminary business case to proceed. And if we don't, we can definitely discuss this and see how we can mitigate any risks we may identify. And last but not least, once all of that has been approved and granted, step number 3 is actually submitting the associated nomination and visa applications per candidate worker, which is quite important. So that concludes the general discussion of how to prepare major considerations for the aged care labor agreement, and that really concludes our webinar. So you may find this fact sheet that you see on the slide, which actually discusses it's a fact sheet on how the aged care labor agreement can help your aged care facility. It has some key terms, definitions and summaries, and most of the major points we have found today. And if we move on to the next slide, I also want to point out that we do have another upcoming webinar which may be of your interest, which is on how you can become an approved employer for the PALM scheme, which is also quite a very interesting and new scheme that has been redeveloped, which does have some aged care components that have been very recently announced, which is also quite important. So this webinar will be conducted on Thursday, 26th of October at 11 a.m. Australian Eastern Daylight Savings Time. You can also register at the link on the slide. So we are going to answer questions. We got quite a few of them. So I'm just going to give you 1 or 2 minutes just to lodge your few last questions. And while you submit them, I'd like to take a minute to talk about our membership. So obviously, LegalVision is quite known for our membership services, which is a cost-effective alternative to expensive hourly rates that are provided by traditional law firms. So we do provide affordable monthly fees, and you do receive cost certainty, and it is an all-inclusive legal services solution for your business as usual needs. We're talking about unlimited document reviews, including drafting, mending, reviewing business contracts, commercial leases. It also includes unlimited advice consultations with a team of 100+ specialist lawyers. It includes, for example, business structuring, employment contracts, disputes, and many more. And last but not least, we do also cover unlimited domestic trademark registrations and most importantly, discounts on any immigration requirements such as nomination and visa applications. If you do decide to become a member with us, we're more than welcome to join us. And so to learn more about our membership and how we may be able to help your business, definitely request a free consultation and we can discuss this in greater detail. So yes, now we're going to answer questions. Yin, so the first question is the ACLA only available for direct aged care facility owners to sponsor directly? We run an NDIS approved aged care recruitment and placement company. Can we apply for an aged care industry labor agreement and recruit overseas talent?
Thanks for that question. So the ACLA is really only for aged care providers that offer residential nursing home aged care facilities. If you're an approved NDIS provider, so you're actually offering support or care services in home, the aged care labor agreement is not suitable. You will be looking at a company-specific labor agreement. In relation to this question, you run an NDIS-approved aged care recruitment and placement company, meaning that if you're recruiting these roles and placing them in third-party organizations, you're looking at a on-hire labor agreement here. And we can talk to you all about that as well. So it is quite tricky, and it's a really good question as well, because when you look at the aged care labor agreement, you think it encompasses all types of businesses, but unfortunately it doesn't. But your specific business, because you're placing and you're recruiting and placing, that's going to be an on-hire labor agreement as well.
Fantastic, thank you. So we do have many more questions. We have another one, which is, can I get a cost estimate to set up a labor agreement and the duration to establish the agreement? And also we have another question, which is is there any chance the agreement will be refused by stakeholders like the union or the regulatory body? So I'll take a moment to tackle these specific queries. What I will say is a cost assessment, we can definitely discuss that, and it will be on a case-by-case basis, simply because when requesting an aged care labor agreement, we do have to prepare a very detailed, business case, which involves many areas which we have covered earlier on in our presentation today. My recommendation would be definitely get in touch with us, request that complimentary consultation, and we will share many questions which we need to receive quite a bit of information before we can make an assessment on the case, which may be risks that we need to attend to and be able to mitigate or tackle in that preliminary business case assessment, and that will really give us a snapshot of, okay, what do we need to prepare and how can we best assist you to achieve those goals? And then we'll be able to provide you with a cost estimate. I would say basically the same thing for, is there a chance the agreement may be refused by stakeholders like the union or the regulatory body? Again, it just depends on a case-by-case basis, but yes, a labor agreement cannot be approved, cannot be taken up by the government. It's really on their discretion to approve so. But in that particular question, most importantly, the business needs to obtain that signed memorandum of understanding with the relevant union before being able to lodge or submit that request for an ACLA. So it's a two sort of part, two answers to that particular question. So thank you for those questions. Moving forward, typically, what is involved in a business case for an ACLA? Again, I believe we have tackled that, but do you want to?
Yeah, that's a great one too. But I might come back to that question because there is another question around approximately how many labour agreements of any kind have you helped establish within the aged care industry and early childhood industry? I would have to check our file. It's quite a lot, and we do this regularly as well. We work across, or we have expertise in all areas of the labour agreement, from DAMAs to company-specific labour agreements, industry-specific labour agreements as well. We have worked with a number of healthcare organisations, and they may be suitable for different types of labour agreements depending on the initial complementary assessment and the strategy advice that we give as well. So I can't calculate a figure from the top of my head. I'll have to check the file, but we definitely do assist with that. I'll go also to these questions. Can staffing recruiting agencies, specifically in the health, aged, nursing space, apply for labour agreements? They can, but if you are essentially a recruitment and placement company, you're looking at an on-hire labour agreement. And with an on-hire labour agreement, the thing is, these occupations are not on the skilled occupation list. So with that, you can only place the skills on the standard occupation list. But it's not appropriate to use the aged care labour agreement, even though those are the specific occupations that you want, to on-hire them to a third-party organisation. The reason for that is you need to maintain the employment with the actual worker, and the contract is essentially between your business and the Australian government as well. I understand this is a bit of a loophole here, like what would you look into, because company specific is not an option. On-hire labour agreement, it may not be an option here too. So until the Australian government opens more occupations under the on-hire labour agreement, I think there is a little bit of a obviously challenge here for you. The next question is, can you please advise the age of the applicant can be up to 45 years or up to 55 years? Up to 45 years under the aged care labour agreement for the 186. There doesn't seem to be any age concessions. And is it something you could negotiate through a deed of variation after a period of holding the aged care labour agreement, possibly. Again, it's through a deed of variation. You would have to submit a very extensive business case as to why you want those concessions to be varied. And again, that is assessed on a case-by-case basis, not just from us, but from the Department of Home Affairs too. So I couldn't say no completely, but I couldn't say yes. So it could be, it's probably a maybe here.
I may just add briefly, if your business is really dealing with, migrants that are close to that age, 45-year age limit or above, obviously, most migrants will be interested in transition into permanent residency, and the business also to retain those skilled workers. What I may say is, in those particular and isolated circumstances, it may be best just to assess, can the business consider a DAMA labor agreement in a specific regional area that allows for any of these particular skilled occupations to apply under the DAMA, which may have concessions such as up to 55 years of age to apply for permanent residency, but that is really assessed on a case-by-case basis, depending on which specific DAMA region of all the 12 regions are you located in, if you're located in the DAMA regional area, and if those occupations are in that DAMA specific occupation list. So just wanted to mention that there may be some alternatives, but has to be assessed on a case-by-case basis.
Excuse me, sorry. So the next question is, are the skills assessing authority requirements aligned with those under the ACLA for the 3 specified occupations? I believe they would be. I mean, you only need a positive skills assessment for the 482 if you don't have the educational qualifications, as it's one of the requirements. So there's a tiered approach, meaning they either have an educational qualification, or if they don't, then they have some work experience and gain a positive skills assessment, or they don't, then they have this amount of work experience. So you do need to go through that process. And again, that's going to apply differently to any particular sponsored worker that you're looking to nominate. Can you also,
I believe,
sorry, go on.
Yeah, I believe we're unfortunately running out of time. So rest assured that to whoever submitted your questions, if we have not answered those, we will definitely reply to you and assist if you would like to proceed with a complimentary consultation, but we will definitely be providing those answers to you. And we just basically wanted to take the time to really thank you for participating in today's webinar. We would really appreciate it if you can complete a 30-second survey and definitely include your contact details to receive that complimentary legal consultation, just to discuss how we can best navigate your current situation and meet your migration goals. So that concludes the webinar for today. Thank you very much for participating, and we'll look forward to hearing from you soon.
Thank you, everyone.